So hello everyone, I'm Lauren Davis. Thank you, Benji, for the introduction. Okay, so first and foremost, just a quick disclaimer that this is not legal advice, so if you want to take 5 seconds to read this full paragraph, that'd be great. Okay, so we're going to start off today just briefly talking about the many different laws that prohibit discrimination. There are state and federal laws. We're going to focus mostly today on the federal laws, just because employment discrimination claims are one of the most heavily litigated areas of employment law. So understanding these laws up here can really help employers efficiently respond to employee concerns and minimize your risks. So some of the ones listed up here that we're going to go over are Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, the Family and Medical Leave Act, the Fair Labor Standards Act, the North Carolina Retaliatory Employment Discrimination Act, and the Americans with Disabilities Act. So we're not going to go over all of these, but we're going to focus on a few of the federal ones. All right. So starting off with Title VII of the Civil Rights Act, the Americans with Disabilities Act, the Genetics Information Non-Discrimination Act, as well as the Pregnant Workers Fairness Act. All four of those kick in when the employer has at least 15 employees for each workday in 20 or more calendar weeks in either the current or the previous calendar year, where the calendar year is when the alleged act of the discrimination or harassment or retaliation occurred, and then the previous year is just that immediately prior calendar year. It's important to know also that part-time employees will also be counted toward this 15 employee threshold for these four laws. We're going to briefly go over what each of these four laws cover. So starting with Title VII, this prohibits employment discrimination against individuals based on their race, their color, national origin, religion, and sex, including gender, pregnancy, sexual orientation, as well as your gender identity. And it also prohibits harassment and retaliation. The next law we have listed here is the Americans with Disabilities Act. This prohibits employment discrimination against qualified individuals with a disability and requires employers to reasonably accommodate qualified individuals with a disability unless it causes an undue hardship. Where a reasonable accommodation is typically just like a change in the workplace, or the application process that helps make it possible for an individual with a disability to perform or apply to a job. You can think of things like adjusting a work schedule or allowing leave, different things like that. The next one on this list is the Genetics Information Non-Discrimination Act, which just prohibits discrimination against applicants and employees based on genetic information, including your family medical history or family members' genetic tests. The fourth one on this 15 or more employee threshold count is a relatively new law. It's called the Pregnant Workers Fairness Act, and it requires employers to grant reasonable accommodations to qualified applicants and employees with known limitations related to pregnancy, childbirth, as well as related medical conditions, again, absent that undue hardship. This often requires different accommodations like allowing the employee to have flexible breaks, or changing your company food and drink policies or your dress code, or allowing them to have different sorts of leave to take medical appointments. Moving down to the fifth law listed on this slide, so is the Age Discrimination in Employment Act. This law kicks in when an employer has at least 20 employees for each working day in each of the 20 or more calendar weeks in the current or previous calendar year, same kind of standard as we talked about earlier. This prohibits employment discrimination against employees and applicants aged 40 or older. Okay. So I just used the word discrimination a lot, but didn't really define it. Generally speaking, it just means to treat someone differently because of a legally protected characteristic. And there can be potential liability throughout every stage of the employment relationship, as we kind of list in the second box here. So no discrimination is allowed in various things like recruiting or interviewing, hiring, classifying, promoting, demoting, firing, pay, or other employment conditions. And we kind of talked about on the previous slide the legally protected characteristics federally, which include your age, race, gender, sex, religion, national origin, disability, military or veteran status, and pregnancy. There are also other legally protected characteristics protected by certain state laws, but these are the general ones that you'll think about federally. Okay, switching to more wage and hour and background check laws, but staying on the federal level. The main law you'll probably think of is the Fair Labor Standards Act, which can apply as soon as you have just one employee working for you. So this is the primary federal law governing wage and hour standards for most full and part-time workers in both the public and private employment spheres. It establishes wage and hour standards, including, among other things, minimum wage and overtime requirements for your non-exempt employees, as well as some record-keeping obligations. Two of the key obligations under this act, I'm going to say a couple times throughout this presentation, is that to pay your non-exempt employees a minimum hourly wage that is at least equal to the federal minimum wage, which is currently $7.25 an hour, as well as to pay those non-exempt employees overtime pay for all hours worked over 40 in a work week at a rate at least 1.5 times the employee's regular rate of pay. Moving down quickly to the next one, which is the Equal Pay Act of 1963. This similarly can apply with only one employee. This just amends the Fair Labor Standards Act and prohibits sex-based discrimination in the payment of wages for equal work. And the final one listed on the slide is the Fair Credit Reporting Act, which can apply with only one employee or applicant for employment. This just regulates the collection, distribution, and use of consumer information and limits an employer's use of employee and applicant information provided by consumer reporting agencies by creating specific notice, disclosure, and consent requirements, both in obtaining that information and in taking adverse action because of that information, where the notice is just simply you should tell an applicant or employee that you might use the information in the consumer report for decisions related to employment. And the permission aspect is just obtaining that written permission from the employee or applicant. All right, going to go over the first state level law. The North Carolina Wage and Hour Act, it governs North Carolina employers' state wage and hour obligations. We're not going to go over all the obligations, but some of the most important that we wanted to flag include the first one, which is this required notice upon hire, which is a relatively new requirement. I think it went into effect around 2021. So essentially, when employers hire an employee, they must inform them in writing of any promised wages and the day and place for payment. This is often done in like an offer letter. And then also the employer must inform their employees, again in writing, at least one pay period before any changes are made to the promised wages. So working down to the second bullet, we're going to talk about bonuses just very briefly, as under this act, bonuses are considered wages, and therefore they should be very properly documented with all the terms and conditions, and as well as any other incentive compensation that you choose to have for your employees. The written plans should clearly define the terms, including how it is earned and under what circumstances it may be forfeited. And the final bullet here is related to vacation. And although it is not required under this law or any North Carolina or federal law to give your employees vacation, once you do give vacation, you should have a very explicit vacation policy that has to address certain aspects. I've listed a few of those here. So first, you need to address how and when that vacation is earned, how much vacation time may be carried over from one year to another, when the vacation must be taken, when and if vacation pay may be paid in lieu of time off, and under what conditions vacation pay is forfeited at the end of employment. And it is important to address all these things because ambiguous vacation policies are viewed in favor of the employee rather than the employer. Okay, now actually turning back to the law we talked about on the previous slide, the Fair Labor Standards Act. So we're going to talk about the exempt and non-exempt classification under that act. So as I kind of briefly talked about, the FLSA requires most employees in the U.S. be paid that federal minimum wage of $7.25 an hour. There are currently 34 states, territories, and districts that have a minimum wage above that federal minimum wage of $7.25 an hour. But the states that either have not adopted their own higher minimum wage or have a lower one will still have that $7.25 an hour minimum wage, and North Carolina is currently in that bucket of states. The next one, again, we kind of briefly talked about how overtime pay needs to be paid at not less than 1.5 times the regular rate of pay for all hours worked over 40 in a work week. There are also certain states, not North Carolina, that have varying overtime laws that require overtime pay at either higher rates or for meeting additional criteria. One example we often give is California. They tend to have stricter employment laws, though they must pay 1.5 times the employer's regular pay, not only for those hours worked over 40 in any work week, but also for any work over 8 hours in any work day, or the first 8 hours worked on the 7th consecutive day of work in any one work week, which is kind of a mouthful, but they just have a few additional requirements. Also in California, employers must pay employees twice the employee's regular rate of pay for any work over 12 hours in any work day. So there are exemptions to this federal law, so there are the executive, administrative, outside sales employees, and computer employees exemptions. I'll go over a few of those in a moment, but to qualify for most of them, employers generally must meet certain tests regarding their job duties and be paid on a salary basis at not less than $684 per week. So I'll go over, for example, 2 of the more common ones, which is one we'll go over is the executive employee exemption. So in order to qualify for this exemption, employees must be 1, compensated on a salary basis at not less than $684 per week. 2, have a primary duty of managing the enterprise or managing a customarily recognized department or subdivision of that enterprise. 3, customarily and regularly direct the work of at least 2 or more full-time employees. And 4, have the authority to hire and fire other employees. So again, that's the executive exemption. The other one we're going to go over, I'm just going to go over 2, is the administrative exemption, because it's also a very common one. Employees must, again, be compensated on that salary or fee basis of not less than $684 per week. They must have a primary duty performing office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. And the third and final one for this exemption is that primary duty must include exercise of discretion and independent judgment with respect to matters of significance. So it's really important to pay close attention to you're meeting all 3 of the criteria for that one or all 4 for the executive exemption. Okay, so wrapping up the talk of exemptions, highlight one more that's not as common, but it is the exemption based on business ownership. So there's a special rule for business owners. Specifically, the Department of Labor has stated that an employee who, 1, owns at least a bona fide 20% equity interest in the enterprise in which it is employed, regardless of the type of organization, and 2, is actively engaged in the management, is considered a bona fide exempt employee. So then the salary level and the salary basis requirements do not apply to the business owners. Management, I have italicized there. It can mean a number of things. It can mean participating in the interviewing and selecting and training of employees and helping with the pay or directing the work of employees. Okay, so to kind of wrap up of some of this wage and hour law, it's important to ensure compliance with your state wage and hour laws as well as the Federal Labor Standards Act. So pay close attention to a few of the things we've highlighted here. The first being that you got to confirm your non-exempt employees are being properly paid for overtime at the rate of 1.5 their regular hourly rate for each hour worked over 40 in a work week. This also includes any unauthorized overtime. This must also be paid. So even if you did not authorize it, if they did work, you have to pay that overtime. The second box here is have a prominently posted policy that no employee may work off the clock. This type of work should never be requested or allowed. It just also includes ensuring that if you give employees unpaid meal periods, ensure that those meal periods are entirely free of work, like no checking emails or anything to do with work at all during that time. The final box here is just to make sure you're keeping accurate time records. That is also a requirement under the FLSA. So require your employees to certify the time records. We recommend on like a weekly or monthly basis, and any missed time punches should be documented and recorded accurately. Okay, so actually this is the final slide on wage and hour law. It's just a reminder that comp time is not allowed. Comp time or compensatory time off is a form of compensation where employees receive paid time off instead of overtime pay for working extra hours. This is not allowed for private employers under the FLSA. So we have a few bullets just reiterating that point, that the practice of banking overtime hours for use in later weeks is not allowed. What I've said probably 10 times now, the FLSA requires employees be paid for all overtime. And then this last one, it just says, with all that said, a manager could control can control the employee's schedule in some circumstances to avoid that undesired overtime, which is kind of another reason why it is so important to ensure your timekeeping records are up to date and regularly checked. Okay, switching gears into more of the hiring and onboarding part of employment. So the first bullet here is about completing your federal and state tax forms. So on or before the employee's first day of employment, you should have the employee complete federal and state tax forms so that the employer will withhold the correct federal and state income taxes from employees' pay. This includes the IRS Form W-4 as well as the equivalent state tax form. And then the next bullet here is just to verify that all your employees are legally authorized to work in the United States. The first is required for all employers, which is the completion of the Form I-9. So employees should complete and sign Section 1 of the Form I-9 no later than that first day of employment. And then the employer must complete Section 2 of the Form I-9 within 3 business days of the date of hire of the employee. This part also includes where you're reviewing the documents provided by the employee, evidencing the employee's identity and their employment authorization, which is like their passport or license or whatever documents that they're providing to you. This last bullet is not going to be applicable to all employers, but there is a system called E-Verify, which is an online system that helps employers ensure that workers are legally authorized to work in the United States. This is mandatory in certain states. In North Carolina, it is required for employers with 25 or more employers in the state of North Carolina. And you can just sign up for E-Verify on the USCIS's website. And compliance with that is similar to the timeline for Form I-9s. It's just within 3 business days after the employee begins work. Then you can initiate that E-Verify case online. Okay. My final slide before turning over to Kevin is just going to be talking briefly about a few key employment documents that are going to be at the beginning of the employment relationship generally. The first one is offer letters. So generally, this letter includes information like the employee's title, their work location, their classification as exempt or non-exempt status under the FLSA, if they're full-time or part-time status, or if employment is at will, which it generally is, any sort of compensation terms you'd like to outline, and if the offer is contingent on anything like the authorization to work in the United States or a background check or execution of any other sorts of agreements like restrictive covenant agreements or employment agreements, which we'll be talking about later in this presentation. The other bullet here is your employee handbook. So employee handbook actually serves several important functions for employers. One being it explains an employer's workplace expectations and potential consequences for failure to comply with the employer's policies and procedures. It demonstrates an employer's compliance with the federal and state employment laws that are applicable. And it can answer common questions employees might have, such as what it relates to what their vacation pay is or any other leave laws or other, again, federal or state employment laws that are applicable to them. So you should typically include reference to those sorts of laws, and some very typical handbook policies you would want to have in your handbook include things like an anti-harassment policy, an equal employment opportunity policy, some sort of reasonable accommodation policy, again, depending on how many employees you have, whether it relates to disability, pregnancy, or religion. Specify your timekeeping policies for your non-exempt or exempt employees. And then last, all of your different paid time off policies, whether that's vacation or sick leave or anything else required by state or federal law. Okay, with that in mind, we're going to turn over to Kevin for restrictive covenants.
So before I do this part, just a couple of high-level thoughts on what Lauren just did. So if you're a small business, I know you got the slides. One sort of key thing to think about is how big are you and where are you growing and what applies or doesn't. And you saw some of the discrimination laws at the beginning that variously had 15 or 20 employee threshold counts. So everything we're talking about, for the most part, particularly in that area, as lawyers, we're sort of laying out the legal framework. The legal requirements are a floor, not a ceiling. And so one thing you may think about that's not really in the slides is what is good for company culture, which may be different from and certainly maybe more than the legal floor. And so when Lauren's going through the employee counts, it's important to know those things in terms of where your exposure might lie, but that's certainly not an invitation to allow harassment or discrimination or retaliation below those counts. The other thing I wanted to point out about the stuff that Lauren talked about is, for a lot of that, there's no personal liability, but that's not true of all of those topics. So particularly on the wage and hour issues, if you're a small business and you're the business owner, if there's a harassment case, there may be expense to the company, but you as the owner may not be personally liable in most circumstances, but that's not true in the wage issues. So if you own the business and there's a failure to pay overtime or minimum wage or promised wages, and the company goes bankrupt or you shut down the LLC or however that plays out, you could be pursued personally. So those, in terms of highlighting what's more or less important, I would focus in on those areas. I would encourage you not to mess anything up legally, but pay particular attention to the wage issues, because your assets, your bank account, your personal wealth could be at risk if you fail to comply with those laws. Good on all that? All right, so restrictive covenants, you see a list here. These are things, Lauren talked a lot about employee thresholds. You could have one employee or one independent contractor, and we'll talk a little bit about that later too, and you may want a non-compete or a non-solicit. Depending on the type of business, you may want everyone to sign a confidentiality agreement. So this would be a topic area that's not necessarily limited by how many folks you have working for you or with you. So you see here the list of typical ones. We'll start with the most complicated and hardest one to deal with as a business owner, which is a non-compete. It occurred to me that it may be useful to sort of highlight what, if I wasn't an employment lawyer, I might have heard in the news and then not heard the rest, which is, a lot of times I'll get a call or an email, didn't the Biden administration make these illegal, or flavors of that, or I've had people call me and say they saw on Facebook a post that all non-competes are illegal now. That is not true. Whether or not a non-compete is legal or not is a complicated question, but there is no federal ban on this. So if you saw or heard at some point last year that the Federal Trade Commission had banned non-competes, I would legally describe that as sort of true. So that happened. There's a bunch of lawsuits, as there often are with such things, and then there was a presidential election in November. So what's going on now is there's a federal ban on non-competes that is all tied up in the courts, and the new presidential administration has asked the courts to please not decide on its own appeal for a while it thinks about it. That's not the words they use, but that's basically what's going on. So I think the practical reality is the federal ban on non-competes is probably dead. It's certainly not in effect right now. So what does that mean for you as a small business owner? If you are inclined to have your workers sign non-competes, I would say I would go ahead and do that with all of the restrictions that we'll talk about in a minute, to try and make sure they're compliant. And if at some point a ban happens, you deal with it then. But I wouldn't at this point assume that that court case is likely to result in a federal ban becoming effective. Good on that. All right. So what is a non-compete? A non-compete, in short, is it tells an employee or an independent contractor that they can't go work somewhere else in some set of capacities. And they work for you, they sign this, they go somewhere else, they may or may not be able to do that. These are heavily litigated, they are often messed up. Of all the things we talk about here, this is the one where I would encourage you the most not to repurpose a document. So if you go online and Google or use ChatGPT, you will get non-compete ideas. You may have a friend or a colleague or a family member who owns a business who has a non-compete who says, here, use this, just change the name at the top. That might work, but it may not work. And these are sort of very specific to the business and the state in which you operate. So what are the key inquiries? And there's more detail to it than this, but generally the things that a court would look at are the scope of activities. So that's, what are you telling the person they can't do? And if your non-compete says to your employee, if you quit or get fired, you can't for 12 months work for any of my competitors, period, that would not be enforceable. So the courts in North Carolina and a number of other states have said that you can only limit them to doing certain types of work, which would often be the type of work they did for you. This is often called the janitor rule. So if you have an employee who makes very expensive, complicated widgets for your company, and you say they can't go work for a competitor, whether or not you actually care if they become the janitor for your biggest competitor, if you don't specifically define the language, the court will throw out the whole non-compete, all right? So this requires some thought by you or your lawyer or some combination of you and your lawyer about how grabby are you going to get in your restrictions. And sort of overall thought is, if I'm you and I want a non-compete for my employees, I want it to be as skinny and tight as possible. So what do I really need to protect? Sometimes when we document things, we want to be very broad and throw the kitchen sink at things so that we don't have to think too hard about, well, I'm sure that'll cover what I need. I wasn't very specific, and so the breadth of it will take care of it. The non-competes are litigated in the opposite way, which is you need to be thinking about how short, how tidy can I make the list of restrictions. And that same concept will apply to the other two things. So duration, that's how long it lasts. You will often see a year after employment ends. Sometimes you'll see 2 years. There are sort of specific scenarios, I would say, in general, if your non-compete for an employee is longer than 2 years, I would be thinking very hard about how you would justify that. 2 years is probably okay. I like a year a lot better. It's going to depend on the job. If you have a non-compete that says somebody is restricted for 5 or 10 years, that is almost certainly not enforceable unless they're a business owner and it's in the context of selling the business. Third piece, the territory. So this is where can they not do the thing. So how would you think about this? You think about this in terms of where is your company and where are your customers? And that should sort of be the list. A lot of times people cut some corners here and say things like the entire world or the entire United States. And if your non-compete says that somebody can't do a certain set of things anywhere in the United States, say the scope of restrictions and the duration are both fine. It's a very tight list of what they can't do, and it's 12 months after employment, so I can't really pick at that. If I'm the lawyer fighting with you about this, and you say they can't do it anywhere in the United States, what I'm going to do is take your deposition, and I'm going to have a list of all 50 states, and I'm going to start going down the list. Identify for me all customers you have in the state of Alaska. Identify for me all operations you have in the state of Alaska. I'm just going to work my way down the list and sort of blow up your you can't do it anywhere in America type restriction. So think about where you operate, where you might operate in the near future, and keep that tidy. Consideration. Consideration is a somewhat fancy word for what are you giving somebody to sign a document? What makes the contract enforceable? And what consideration means is something of value that you're giving your employee to restrict themselves. And so what is that? It can be a number of things. You see here 3 examples. There could be other things, but these are the most common ones. And probably the most common is new employment. So different states handle this different ways. In North Carolina, here's the rule. If you have a current employee who's already working for you, who has not signed a non-compete or signed one and you want them to sign something different, you cannot tell them that keeping their current job is consideration. So you either have to give them a raise or a bonus or something else valuable to sign it, or for new employees, they need to sign it either before they start or on their first day. So if you sort of lose track of this and you have a non-compete that otherwise meets all these requirements and it's great and it's enforceable, but you forget to have somebody sign it and 3 or 4 weeks into their employment you say, oh, by the way, we need to clean this up, put the document in front of them, that is not going to be enforceable, okay? And so how do you fix that? Give them a small amount of money, and it does not have to be a lot. There are a number of North Carolina court cases on this where things like $100 and $500 have been deemed to be enough. And so that's how you would fix it, is you would say, I'm going to pay you $500 only if you sign this document, fill in the blank, it doesn't have to be $500. Often the question will be, well, what if they say no? You can make it a condition of employment. So if you're a small business, talent is hard to come by, recruiting is expensive, but at the extreme, you could tell a current employee, this is now a job requirement, I'm going to pay you to sign it, but if you don't sign it, I'm going to terminate your employment. Assuming they're at will and they don't have an employment contract, that would be permissible. You all can think about all the reasons you may not want to set it up that way, but it's certainly a conversation you could have. State law issues, so everything I'm saying about non-competes and non-solicits, this is all North Carolina specific, which probably covers much of what you all in this room are thinking about. But I flag this, if you have workers in any state other than North Carolina, do not disregard what I'm saying, but it requires more thought. So non-compete law, I told you earlier, there's no federal ban, nor is there any federal set of guidance on how to do this or not do it. So it's all state specific at the moment. 4 states have made non-competes completely illegal. Okay? California, North Dakota, Minnesota, and Oklahoma. So if you're operating in any of those states, you can't have non-competes. A whole longer list of states have put a whole bunch of restrictions around this. So for instance, Virginia, a nearby state, has a compensation threshold. So you can only have non-competes with people who are paid over a certain amount of money, which I think is roughly $76,000 a year at the moment. I don't have the number memorized. That's within $5,000 if correct. And other states handle this a whole lot of different ways. Colorado and Illinois have notice requirements. You have to give employees notice or new hires notice in writing before you force them to sign. So we don't need to belabor what each state does other than to flag, if you've got workers anywhere other than North Carolina, you need to be thoughtful about those issues. And sort of at the extreme end of that, so one bad result is if you miss on another state law, your document's not enforceable. That's not great because you were trying to get a restriction. But there are scenarios where you could actually be liable. So for instance, California, Colorado have financial penalties for employers that mess up their non-compete laws. So just be thoughtful about where you are. Yes, ma'am. Either way. If you have a question now, I'm happy to answer it now.
Hold on, sorry, let me get your microphone, yeah.
Just what's causing the ban, or what caused the non-compete ban, and how can we protect ourselves, protect our interests in our business? How do we go around that if there is an out?
Sure. So again, the ban is likely dead in the water on a federal level. I would expect, so the obvious trend is states are becoming more, not less restrictive with non-competes. So there are more state-level non-compete bans now than there were however many years ago. So certainly a trend to tightening up. What's causing it? So the federal government, when it rolled out this rule, also pushed out a 280-page set of findings back up for why they did it. And the general idea is it's anti-competitive, and depending on how you look at it, you could quibble with their logic. But they basically said it was suppressing wages and that it would unlock economic opportunity to get rid of these things. In some cases, the other lens would be, depending on your business, if you're investing a ton of money in people and you have a high-tech business or you have very confidential trade secret information, which you can still protect, I think it can hurt companies in some areas if you invest a lot in a worker and train them up, and there's no restriction on them moving across the street and setting up a directly competing business doing the exact same thing, applying all that they learned from you. But the logic was, I don't know that they used the term anti-competitive, but that was the concept. It was suppressing wages. It was keeping people from moving. And there is truth to all that. They had a bunch of data. The other thing, the sort of conceptual problem is people abuse these things, right? So there's some very famous, infamous cases. Like Jimmy John's got involved in some huge lawsuit. If anyone owns a Jimmy John's, I'm sorry, it's just a case. It's the one that comes to mind. Query like should Jimmy John's have non-competes that keep sandwich makers from going and working at Subway? I'm sure if you own a Jimmy John's franchise, you would raise your hand and say, of course we should be able to do that. But a lot of people are going to say, frankly, that's dumb and that's not the intent of these things. And so part of the problem was these were getting abused. People were throwing non-competes at workers who probably shouldn't have non-competes. Receptionists, like they'd have the whole company sign a non-compete. So I think that's sort of the impetus for where this came from. In terms of how you protect yourself, the rest of what I'm talking about is a lot easier. So one thing that I would think about if I was in your seat is, do I really need a non-compete? And if you're my client, that's the first question I ask. I want a non-compete. Okay, why do you want it? Well, we're worried about our customers and our trade secrets. Okay, well, if I got a deal for you, we can protect that stuff without a non-compete. And so if you take the non-compete component out of it, which I'm not saying you have to do, you can draft enforceable non-competes, life will be easier though. So if you have a restriction that only protects your customers and protects your trade secrets and your confidentiality, a court is much likely to let that pass muster. And frankly, employees are much likely to fight with you about it. You know, if you have a former employee and they take an agreement to a lawyer and say, get me out of this, and all it says is they can't solicit customers with whom they personally worked and that they can't use your trade secrets, the lawyer's not going to be able to do much for them. I mean, if I'm their lawyer, I'm going to say, you know, understand you're frustrated, but the court's going to enforce that. And so that's probably how I would attack this in an environment that is becoming more critical of non-competes. And again, you may have jobs or certain categories of jobs where they make sense, but I mean, you see right here, bottom thing, courts more often willing to enforce this. So for instance, in Oklahoma, non-competes are illegal, but non-solicits of customers are not illegal. So you see there, a state government decided like that's a reasonable thing to allow to be protected. That answer? Okay. And so you see here, non-solicits come in different flavors. I would be careful here, you know, there are court cases in North Carolina that have said a non-solicit that covers all of a company's customers is too broad, that an employee should only be restricted from customers that they know anything about. There's some conflicting case on that. If you're a small business, maybe all your workers know all your customers. If you're a giant business, you know, should I not be able to solicit customers that I didn't even know exist because they're 2 divisions away and I don't even know they're our company's customers? Probably not. So just, again, this would go in the category of you got to be specific to your company and be thoughtful about it. I'm not bored with you. I'm just making sure that we've got 6 minutes and 60 slides left. So, so that's basically the rub. I mean, I'll sort of blow through the rest of this, and you have the slides. Confidentiality and trade secrets. You know, again, we're going in order from things that maybe you don't need to, depending on your business. I mean, you may not even want to non-solicit customers, but you don't want people running off with the formula for Coca-Cola, right? And so some of that's protected by law. I would always put an agreement in front of people if you have confidentiality or trade secrets info. Quick thought, don't get trapped with new hires. So this is the other side of the coin. When you are onboarding people, Lauren talked about onboarding, I would ask every person before you bring them on, like at the conditional offer of employment stage. So you send them an offer letter, which Lauren talked about. I would include in my offer letter a specific representation for them that they are not bound by a non-compete or non-solicit with anyone else, or that they've disclosed it to you. Because you, at least in theory, cannot be liable for things you don't know anything about in this area. But if you know somebody has a non-solicit or non-compete and you hire them anyway, and whatever you're paying them to do for your company breaches that non-compete, you can get sued. Your business can get sued, and you can be exposed. So I would tease that out on the front end rather than finding out the hard way later. This happens a lot, right? Sometimes it happens inadvertently because people aren't thinking about it. Sometimes people don't know they sign non-competes. Non-compete, in theory, if written well, could be enforceable even if you signed it 20 years ago. Sometimes people just don't even remember they had one. Sometimes people know that if they disclose it, you won't hire them, and they're hoping that that isn't anything anyone asks about, so they just don't bring it up. So I would affirmatively ask. So in the so lunch is there. So if you all start leaving the room, I will not be offended, and I'll be around too. So employer independent contractor. This is not on the slide. Here's the concept, particularly for small businesses and startups that we see a lot. So not on the slide. You don't have to write this down. Please remember it. There's no such thing as a 1099 employee. So I've been doing this longer than I like to admit, and some of my gray hair is from work and some is from the kids. But I can't tell you how many times I've heard this. People call up, and it's rarely in the form of a question. It's often in the form of a statement. So I have this 1099 employee, right? And then I get like a few more gray hair, and I let them finish about how they're handling their 1099 employee, and this person's been working for them full time, 60 hours a week for 20 years, and always been paid on a 1099. You cannot do that, okay? So nobody has to raise their hand and confess, but if you have such a situation, I'm not a tax expert. That was the person before me, but you should flag her down privately and talk to her about this. So, an employee is paid on a 1099, or excuse me, employees paid on W-2, independent contractors paid on a 1099. And we'll talk a little bit about what that means. You can have an independent contractor who's an individual. You'll see, like, it is not a complete solution, but it is better if you're going to have an independent contractor to be contracting with businesses, not people. I see Secretary Marshall in here, so I don't get too close to her expertise, but her office can help individuals set up businesses, and anyone can go set up an LLC. So that's not a complete solution if it's just sort of papering over an underlying problem, but it's functionally better. Government investigators like to see you contracting with businesses, not individuals, but you can have individuals. You see a chart here. I'm not going to belabor this. Lauren talked about I-9s. So here's sort of the rub about all of this. So you see under independent contractor, that sort of sounds better, right? I'm not exposed to wage and hour laws, and I don't have to do I-9s, and I don't have to do payroll taxes, which is better if it's actually an independent contractor. So this sort of, like, why it's better is tied into the problem. Some companies are motivated to put actual employees in independent contractor status because isn't that easier and we don't spend as much money, which is good until the government agency that deals with taxes or I-9 shows up and says, these people are really employees, and then you have a problem, okay? So the takeaway from this chart is not, I'm going to pick the column that seems easier. That sounds fun. I'm going to make them 1099s. That's not the right answer. This just shows if they're properly classified, what fits in what thing. All right, thing in red here, this is other than, hey, help me with my 1099 employee. This is probably the other thing I've heard the most often over the years, which is, yeah, but they want to be an independent contractor. And that is often true for many of these reasons, because if they're an independent contractor, at a set rate of gross compensation you're paying them, which check is bigger to them if they're a contractor or an employee? The contractor is socking away more money. Now, they're supposed to pay taxes, but if you're the employer, you don't have eyes on that. You don't know what they're doing with their 1099 and whether they're doing the taxes appropriately. Plus, there's payroll taxes, which is 7.65% per side, right? And so on like its most simple level, if you pay somebody the same amount of money as an employee that you would pay as a contractor, you're both paying 7.65% of that amount of money in payroll taxes, right? So already both oxes are being gored. I'm sure that's a terrible mixed metaphor. But so a lot of times people call it like they want to be a contractor. I'm sure they do. I also hate paying taxes, but it's part of life. And so the key is not who wants what, is do they fit the test for a contractor? I'm sort of out of time to go through the slides. Here's the other thing I'll say about this. Another thing you may have seen on the internet or on the news, flavors of the previous thing I said, the Biden administration pushed out a new test for independent contractors. Everyone in this room could probably guess whether that made it harder or easier than the Trump rule on being an independent contractor. So the Biden administration put out a rule that would have made it harder to pass the test for having somebody as an independent contractor, meaning the government agencies would have been able to squeeze employers more and say, these are actually employees, therefore pay taxes, pay workers' compensation insurance, pay unemployment taxes, these should be employees. Legislation and presidential elections don't always, well, these are administrative rules, not legislation, but this is where the sort of system doesn't always work great. So the Biden administration rule became effective in late 2024. There was an immediate lawsuit, a federal court issued an injunction staying it, and it's much like the non-compete rule. So the rule is not dead, but now the Trump administration is in charge of litigating this rule that it doesn't like in the first place, okay? So this is not like a legal civil procedure seminar, which I would not be good at giving anyway. But what I'll tell you is, much like with the non-compete rule, the Trump administration has asked the court to please slow down on ruling in its favor because the Biden administration made the appeal. The Trump administration wants this rule gone and wants to go back to the old rule, right? Here's what I would say if I was you, how does this affect my life? I would say if I was running a small business, I wouldn't let me be affected at all. I would be very cautious about this. And I would handle this in a prudent way because the costs of getting this wrong are enormous. And presidential elections happen every 4 years, and you kind of don't want to be in a chasing your tail situation, right? You don't want to establish a way of doing things, and the rule switches, and you've been loosey-goosey with this, and now you've got a bunch of exposure. So you'll see here in the slides, a list of things that are factors. None of these are definitive. So even under the Trump rule, so the Trump rule had two key factors, which were who has the opportunity for profit and loss and who controls the work. You know, without reading the slides to you, I would say things that I might be thoughtful about. Is this core to your business? So if your company, your small business, makes widgets and sells widgets, that's what you do. If you have an independent contractor who is making widgets, I would have serious concerns about that. That is your company, right? So what's an independent contractor? An IT specialist who comes in and cleans up your servers and sets up your phone lines and new hire computers once a month. Your landscaping company, somebody who does maintenance on your facilities, perhaps if they're not full time and they come in, and sort of tied to the previous thing I said. If you have an employee doing the exact same thing as an independent contractor, that's generally an immediate red flag for a government investigator. Does that mean it's impossible? Many things are not impossible, but that's something that if you get audited is going to catch attention. And so I would just be thoughtful about this. I know when you're starting up, cash is at a premium, and as we talked about, it costs less to have independent contractors in most cases than employees. But I would just be very thoughtful. I'm going to skip over all this, which you can all go look through in the materials. On this set of factors, none of these are definitive, but so the more you tilt in your favor, the better. So if all of these look like independent contractors, you're going to pass all those tests, and the only thing is your contractor agreement was with Lauren instead of Lauren's Contracting Service LLC. Are you going to get popped by an investigator? Probably not, if that's the only thing. If everything she's doing is actually true independent contractor work, the fact that you contracted with her instead of an LLC is probably not going to be definitive. But even under the Trump rule, and the state of North Carolina handles this differently, the state of California handles this differently. There's all these different tests. We don't have time to talk about all the tests. But there's never a one-factor test. And so the exercise, if you're in the seat you're in, is how many of these bullet points on these 6 or 7 slides can I tilt in favor of looking like a contractor? And I'll finish up with this, which is the solution. So people say, all right, well, what do I do then? This is something where you can be wrong in one direction but not the other. So you can create a lot of liability making an employee an independent contractor when that person should really be classified as an employee. You cannot create liability, except at least not in any of the areas we're talking about, by making somebody an employee. If you properly onboard them as an employee and you follow all the wage and hour laws that Lauren talked about, no government agency is going to ever say, well, you should have classified them as an independent contractor. You can always hire somebody as an employee. So that's solution one is, because oftentimes what I'll hear, they want it and we want it, the thing that was in red. The other thing you'll hear a lot is, well, they're not full-time, or I don't need them that much, or I only need them here and there. Make them a part-time employee. Come up with an hourly rate that makes sense. If they're not working that much, you're not going to have overtime exposure anyway. Just come up with a number and then make them a W-2 employee on a part-time basis. And you have solved all of your problems, and you can play with the math to account for payroll taxes. The other thing you can do is use a third-party agency. I would say that is directionally helpful, but again, not a perfect solution. It is possible, like if it's clearly your employee and you're using an agency to misclassify them, you could still end up liable as a business owner. So that's sort of the summary. I know I blew through there, but I appreciate the question. I'm happy to stand up here for as long as you want until somebody else comes up and kicks me off stage. She has the mic, so I'll go there first, and then we'll get you a mic. How's that?
Okay. Hi. Thank you for all of that information. It was very valuable. So I just wanted to clarify where it was speaking of the independent contractors. So they should actually go through an onboarding process. For example, I'm a professional doula. I also have a team of doulas because I can't be at all the births. So I have them as independent contractors because they don't get the caseload like how I normally do. But if I'm booked, then I give them those. So as far as like standards of practice or HIPAA and things of that nature, just get them to sign those documents versus presenting it to them as an onboarding process.
Okay, so I think I'm answering the question, and you tell me if I'm not. Okay. So even in an independent contractor relationship, there may be company documents that it is appropriate advisable and necessary to hand to that independent contractor. Policies and procedures, confidentiality agreements, a HIPAA business associate agreement. So I can think of a number of things where even if they're properly classified as an independent contractor, you may still have certain documentation. Not the least of which is they're going to have to invoice you and you're going to have to pay them somehow. So if the question is, don't I still need some documentation? Yes. I mean, the scope of that, Lauren talked about employee handbooks. This is in one of the bullet points that I blew through. Like, I would not give an employee handbook to an independent contractor and tell them to sign off and say they'll comply with it. Because if you get audited, an auditor is going to say, well, if they're not an employee, why are they signing an employee handbook where it says employee acknowledgement? There may be some policies, like this isn't the situation you're describing with the doula, but like if you have a physical facility and people are coming in as independent contractors, you may have like safety rule, a manufacturing facility. You must wear safety goggles and a hard hat and a vest, whatever it is. You may want everyone, even me as a visitor, to follow those rules. And so you might have a certain set of safety rules for independent contractors. So it's probably beyond the scope of me standing up here to say, like, specific to your situation, what documents are or aren't appropriate. But in general terms, yeah, I mean, I think, like, particularly a HIPAA issue, which is out of my range, that's the, Benji, I think the 2 o'clock session. David Center will be up here later. I don't know enough about HIPAA to ask somebody else.
Okay.
But yeah, sort of conceptually, you would want them to sign appropriate documents, but not ones that indicated employee status.
Okay, thank you.
You're welcome.
So just jumping in just real quick, I think one of the things we're trying to kind of illustrate here from the morning sessions is kind of all the overlap of the issues. So I think you see a lot here, this classification of employee versus independent contractor. We were hearing from Julie about tax withholding and how they pay taxes and whether or not we withhold taxes. And so the treatment of people as an employee versus a 1099 independent contractor has lots of ramifications, not on your business, but also on the people you are bringing in to be service providers for you. So I think just trying to reinforce like we started with formation, then we went to little tax, and we went to little accounting, now we're gonna do a little, like it all kind of flows through understanding the small questions have big picture ramifications. We had one more question here, but I also, before we do that, I do want to introduce everyone. We have Secretary of State of the great state of North Carolina, Elaine Marshall, here in our midst today. Really appreciated your commitment to small businesses, Elaine. It's just really amazing. Okay, one more question.
Yeah, and as Benji's handing the mic off, she made me think of a better way to say this. So the risks do not all flow in the same direction. So here's what I'd say. One way you think about this, if you don't want to memorize any of these slides, is default to employee, not independent contractor, and then convince me why contractor is right. Okay, so that's one way you could think about it. Same thing with exempt, non-exempt. Default to non-exempt, I'm going to owe this person overtime, and then convince me how they can be exempt so that I don't have to pay them overtime. And if you start with that framework, you may get to where you want to be, which is independent contractor or exempt, but you're not going to mess up the same way as if you just pick where you want to land and start there and work the other way.
And we recognize there's a balance here between cash flow and the ability to treat someone as an employee. But the important thing is that you come into the conversation with knowledge that there is an issue here we have to address. And then your risk tolerance of understanding good or bad. Sorry. I just got yelled at so the point here, we understand that cash flow is an issue and that it affects how you pay people and whether or not you can pay them cash. The point here is we understand also that cash flow issue, but we want you to be informed about the issues and understand the risks associated with them. Okay, so now I'm going to give it back to you.
You have all the time. We have held you on this question so long. You have all the time you need. Let's stay up here until you're happy, because I'm sorry we kept stealing the mic back.
Rock and roll. Thank you. No, quick question. You were talking earlier about the non-competes and contracting. So if you're an entrepreneur that uses Fiverr, Upwork, Thumbtack, and you're contracting with these independent freelancers, can you have them sign a non-compete? Like, I'm a designer, and if I hand off my design that I concepted, right, to somebody to create a brochure or finish out a large project, how do I protect my intellectual property from them saying, this is my work, I did it, and as far as like a non-compete?
Yeah, so I'll tell you, buried in those bullet points, it says don't have contractors sign non-compete. So that would be one of the things where, like, if all the other factors are right. And so what's the reason? You know, one of the things that I would say in an independent contractor agreement I would suggest is not only, you should not prohibit people from working elsewhere, you should encourage it, because that's part of being an independent contractor, is they're selling their goods and services to multiple different businesses. That said, North Carolina courts will enforce non-competes against independent contractors if they meet all the requirements. I guess my response to your question is, I would sort of, like I was thinking through earlier, maybe, do you need a non-compete? Like, do you care where they're working, or you want to protect your stuff? And if you want to protect your stuff, I think you build in a robust confidentiality, trade secrets, IP assignment, inventions assignment document into what you're doing. And without knowing your business, my immediate reaction to that is, how good is the paper trail on you came up with it, not them? So, you know, right. So that's probably the end. Like, it's assigned, you know, IP assignment or trade secrets protection is only as good as being able to prove who owned it in the first place. So if they're going to raise their hand and say, I came up with it, and you don't have any paper trail to prove them a liar, the covenant's not really going to help you. But if you have the first part, which it sounds like you do, which is, I can prove definitively I created this, then that layered on document of a, you know, confidentiality, trade secrets protection, I think that's probably the complete solution. And I would say, do you really need a non-compete? I mean, if they can go work wherever they want, but they can't use any of your stuff, haven't you solved your legitimate business need?
I guess one other question is, or if I didn't word it right, like, we can't decide if
Sorry, without a microphone, we're live streaming and everything. Nobody can hear you.
if they're an independent contractor here, North Carolina, somebody works for Fiverr, they pick up a client that, or I have a client, now they are going back and trying to do work. That's what I'm kind of saying. Like, Upwork and all these freelancers, there's no parameter where they can't work, but how do you make sure that somebody that you hire for one of these freelancers is not working for the graphic designer that lives 15 minutes down the street from me?
Yeah, so you could, I mean, I guess you could call the graphic designer a customer or vendor or supplier or something. You know, again, I guess my sort of high-level thought is I would be as narrow as possible. So if you're trying to protect the graphic designer relationship, I would spell that out, which I think is different than a non-compete. So you don't care who this person that you're working, you don't care what they do as long as they're not touching that universe of designers. I would define that away. And I can't sort of, I mean, I could draft it for you on the fly standing up here, but the seminar would end. But so that's what I would think about is that's not really a non-compete. There's a group of people, I don't want them poaching. And so I'm going to specifically define what that group is and what they can't do with that group. And I think even for an independent contractor, that's potentially enforceable.
I don't know if, and also I think it's also looking at the standard contract that you are being asked to sign or you are utilizing in the relationship, understanding what it says and how it might need to be changed or augmented with an addendum. Right? If you're using an Upwork standard contract and you're like, oh, that's not quite exactly what I need, then you need to change it to make it what you need it to be.
And the other thought, just sort of the human side
And
of
lunch
this.
is served.
Sorry, I wanted to say, I mean,
Go ahead.
Smith Anderson will be here
Yeah,
for the
we're
rest
around.
of the session. Plus, you can also apply for the individual one-on-one coaching session. I'm sorry, we went way over time, but Kevin, I know you have a lot of great information as well as you, Lauren. But I do want to make sure everybody gets to lunch where we will have the panel session. It will start in a few minutes, so take a moment
And
to,
that's upstairs.
restroom break. Yes, thank you. And then we'll be back here again for, I believe, 2 more sessions after lunch. But yeah, so take a break, get some food, and yeah, and like Benji said, upstairs in the ballrooms. Thank you.